This sentencing hearing before Judge Boyd wasn't about excuses. Despite arguments for probation and second chances, the court focused on one moment that changed everything. By the end, Judge Boyd made it clear, some crimes leave no room for leniency.
Judge, that's it.
All right. Did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right. So I want to let parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says, regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure.
But then she comes back and she does make a comment. And it says, the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
And that we addressed actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of the process of explaining that to her. So I think that was, she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that, contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this. She did not possess or hold a gun. And so I think it's to Ms. Ballard's point in the TSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. The point of the matter is that she was in the car and not actively terrorizing these people. I made a distinction, but I also understand that she's there as part of it.
All right. Because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
You know, working responsibility for the film. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I wasn't one of our advocates, so this on Zoom was dressed in a brown sweater. She said she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge. I just wanted to make sure.
Okay, thank you. All right.
I don't want to overstep, but I do want to make a brief argument this time.
Yes, you may proceed.
Judge, when I started representing this young lady, she was in jail, and as her mother said, usually I have to deal with questions: how quickly can we get out of jail? I think Ms. Franklin took a very approach for a single mom. That is that I want her to sit. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to penalize or punish for the things that you do. So 5 months passed by, and so I think that the value in that here in the courtroom today is she has a taste of incarceration. And I think she's come out of jail, Judge, from the Roosevelt High School. Ms. Howard said she's really doing well in school. It's hard for me to believe she's 17 years old when I went her and charged with such a serious crime. And she's turned 18 and she's only, 3 months into her 18th year. So, Judge, one of those things, she's got a bright future. She's got, hopefully, acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get from the defense. And that's a really fine letter that supports Kayla in her application for probation. I don't want the court to think that she's minimizing this, because we've spent talking about, the what ifs, and you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Marks, and Mr. Harris is very good through the juvenile probation and through the practice of bringing young people in, specializes in young offenders, and working with them with this cognitive behavioral. You can't find yourself in this situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this is put square upon Kayla. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother is never better. I just really beg this court to give this young woman a chance. Conviction, being sent to prison, would is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path, and we'd like for her to stay there in the court's commission.
Judge, the situation here is that specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what you're gonna have to make going forward. It's something that the state feels that prison would be appropriate here. Victims feel that it would be appropriate here. That's what we're asking.
Judge, I just want to see more of these PSIs than I do, but it looks like the juvenile offenders, I think, have the more serious role in this. I can't read this correctly, but it looks like one of them had his case dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, judges argue that there will be some kind of equitable position here by the court to figure out what to do with Kayla. Again, Judge, deferred adjudication on second degree felony is a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's morsel, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the county jail. I think she spoke about her to jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway court and give her a chance in the future without being another young black female with a conviction on her.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentencing is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I would have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations.
The defense emphasized youth, education, and rehabilitation. But Judge Boyd turned the focus to responsibility, victim trauma, and a child trapped in the middle of a violent crime. The court explained that sentencing is not only about growth, it is also about punishment and public safety.
Stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court.
Isn't that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, where there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right through one thing I did notice in the letter for the psychiatrist, something that is false, I've seen it somewhere in here, is that Ms. Johnson, she stated she gave them a ride but did not know their intentions. She played her role in boxing. She says that she had never had or handled a gun that night. Police let her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought into the report that she had mentioned that. She said that they threatened her. So it's just something that is,
Well, I don't, but it's feeling, so it's not going to be in a police report. But I can tell you that was her feeling on this. She didn't feel threatened by these two young juvenile offenders. We're here today to take responsibility and not make excuses. So that's all, Judge.
All right. This is anything else before the court makes its ruling?
Move on.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right, after this case, it will be Mr. Serta. All right, court is calling 2018 CR 0858, State of Texas versus Christopher Lemire. Can I have the parties announced for the record for the state?
Wilson from the state, Your Honor.
defendant.
And are you Christopher Lemire?
Yes, sir.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Christopher Scott Lemire who was placed on deferred adjudication in 2018 CR 0858 for the offense of burglary of a habitation on May 13, 2019 for a term of 6 years? Is that you? State?
Your Honor, do you have a supplemental motion?
Let me see. Yes, and I'm also showing you the state's motion to supplement motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney as well? Did you understand it?
Yes, Your Honor.
All right, and counsel, the court was just tendered the supplement. Are you prepared to proceed?
We are prepared, Your Honor.
All right, state.
Violated condition number 33 on or about the 17th day of November 2023 in Boone County, Texas. Defendant Christopher Scott Lemire did then and there fail to comply with the rules, regulations, or instructions of the res care facility. And that the defendant threatened other residents and destroyed property in violation of condition number 33.
How do you plead to that? True or not true?
Your Honor, we waived the other violations alleged in the motion.
No objection, Your Honor.
Do you understand by pleading true to violation of condition number 33, the court can find it true, grant the motion, sentence you up to 20 years in prison and up to a $10,000 fine?
Sure.
Knowing that, do you still wish to plead true to violation of condition 33?
Yes, Your Honor.
Court will find violation of condition number 33 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on deferred adjudication, and we're asking that you attend the state ISF cognitive program, Your Honor.
All right, is this going to even work? Because respite care was intensive and that didn't work.
Difference, Judge, from what I remember from the last hearing, September, when we had these questions for res care, are y'all going to make sure he does the GPS? Are y'all going to make sure he does these things? And my from that hearing is they're like, we'll do our best. It's not really up to us. I think state ISF is more structured. My understanding, they are going to make sure he's complying with his probation, Judge.
And Judge, we've actually had issues with rest care.
Judge Boyd acknowledged the defendant's progress and future potential, but the seriousness of the offense outweighed every mitigating factor. The sentence was imposed, and the court moved forward.